Thank you for joining me today for Washington's Estate Plan for You. Hi, my name is Lynn, St. Louis, and I am an estate planning and elder law attorney at ELG Estate Planning. And I welcome you to today's topic, which is all about what Washington has in mind for you if you don't have your own estate plan. So a lot of people think that if they have no estate plan in place, well, they probably don't actually give it much thought. If they don't have an estate plan in place, what will happen? That's probably more of a head in the sand type approach. And I congratulate you for being here, because what that means is that you are interested and want to know more. And that's one of the things that's really important to me as the founder of ELG Estate Planning Elder Law Group, is to make sure we share information so that people can take action to protect themselves, their family, and their assets. And I can tell you that Washington's estate plan for you is not the way for you to protect yourself, your family, and your assets. So without let's go ahead and let's get started here. Keep in mind that if you're joining me live on the webinar today, you can put questions in a chat and I will do my best to answer them before we conclude today. So I'm actually going to share my screen with you because I find that that makes it easier for me to talk about Washington's estate plan. We are first going to talk about what happens if you don't have a will. We're also going to talk about, well, a will is not an estate plan. A will is just one component of an estate plan. Also included within an estate plan are your durable powers of attorney, your healthcare directive, and then any other types of trusts or anything you have in place to protect your assets, especially against long-term care costs, so that you can receive government benefits. So there's a lot we're going to talk about, but let's start with the most obvious question people have is, what happens if I die without a will? And you should be seeing something that's called intestate succession in Washington State. And the statute RCW, Revised Code of Washington, 11.04.015. Why I'm showing you this screen is that I found that this is helpful for folks to actually see the visual, and they can put themselves in the situation to know what happens to them. So what we're going to start first is, are you married? If the answer is no, then you are going to be looking at, okay, let's go down this side of the chart. So no, you're not married. Do you have living descendants? Do you have kids? Do you have grandkids? Do you have great grandkids? That's what's meant by living descendants. So if the answer is yes, then 100% of your estate goes to your descendants. So let me take a moment here to share with you, what does that mean? Let's take a really simple example. Let's say you have 3 children. They're all living, they're all adults. Your estate will be divided. Remember, you don't have a will. Your estate will be divided equally among those 3 living children, which means each of them will get 1/3, 1/3, 1/3. So that might be exactly what you want. So the state of Washington is trying to accomplish what they think that most people would probably want. And in this case, that might be exactly what it is, 1/3, 1/3, 1/3. Let's say that one of your children is receiving government benefits that are what we call needs-based government benefits. So their inheritance of 1/3 of your estate will then stop them from receiving benefits until they spend down the money. So that is a really poor outcome. If you have any special needs child or a child that has problems with handling money, you're going to want to have a will that contains a trust within it to make sure your child can keep receiving those benefits or doesn't spend their money in a way that could be harmful to them. Let's say out of these 3 children that one of them is deceased, but they left 2 kids, your grandkids. So the laws of intestacy of the state of Washington for a single person then say that 1/3 will go to child number 1 who's surviving, 1/3 goes to child number 2 who's surviving, and the deceased child, child number 3, who has 2 kids, their 1/3 share is going to be divided equally among their 2 kids. Your 2 grandchildren take the place of the parent, your deceased child, and they will each get 1/6 and 1/6. So that's very commonly what we will see when people don't have a will. I would be remiss if I didn't mention that all we are talking about here is what passes through a probate estate. With a will, there is a probate. Without a will, there is a probate. The only way you avoid probate is if you set up your estate to avoid probate, which can be done in many different ways. But will or no will, unless your plan, you set up a plan, which if Washington has a state plan for you, you haven't set up a plan, there will be a probate. And when it comes to who's the executor of your estate when you don't have a will, it's going to be whomever the court appoints. That may be one of your children, they're an interested party. It could be somebody else, maybe even a professional if the 3 kids don't agree and they fight or they're not qualified or multiple reasons. So typically without a will, the probate is going to end up being a bit more expensive than if you had a will or if you avoided probate altogether. So you have the expense and you have the potential for conflict when you don't have a will. As I mentioned just a moment ago, this 1/3, 1/3 division under my example for the single person that has 3 kids, that's only for the assets that would pass through the estate, through a probate. Well, what's missing? Well, maybe you have a 401k or an IRA or a 403b or any of the other alphabet soup for retirement. So what that means is likely when you got that account, you filled out what's called a beneficiary designation on that. And you may well have said 1/3, 1/3, 1/3. So that is actually a bit of an estate plan that you have because you actually gave direction to an asset. If you didn't give direction to the asset, then it pays to the estate. And then if it pays to the estate, it goes under the same set of rules that I've been talking about, which is equally to your children. So if you have a beneficiary designation on your retirement account, it pays to your children under tax laws. They have 10 years to take out the asset, their share. It's called RMDs. They have to pay taxes on it. If it goes through your estate, then it is a 5-year payout. So it's advantageous from a tax perspective to make sure you have a beneficiary designation on your retirement accounts. Let's say that because you didn't want to, see the attorney, didn't want to get an estate plan in place, you decided to put one of your kids on your investment account or your bank account. And oftentimes, whomever you're seeing at the bank when you set up an account, they say, oh, well, you want to avoid probate, right? And it's like, yeah, I don't want to go to probate. And so they say, just make this child of yours a joint tenant and joint owner with right of survivorship. They won't say that because they're not thinking that, but they'll say, let's make it a joint tenant on your bank account. And that could be a small account, or it could be a really big account. It could be a big part of your estate. What happens? Well, the laws of intestacy are not applying to make it one third, one third, one third, because through the titling of that asset, putting your one child on that account, they, upon your death, are the sole owner of that account. Let's say it's a big account, it's $600,000, for example. They have $600,000. Now, you may have talked with your child and they said, of course I'll divide it, Mom. Of course I'll give one third to Bobby and one third to Susie, and I'll keep one third. Well, it's their money, technically, and they may or may not comply with that. I don't know, but I can tell you that this is definitely a great opportunity for the children to get in a fight and to sue each other, and lots of legal fees to figure out, does the one kid get to keep the 600,000, or do they need to divest themselves and keep only 200 and divide the rest? So maybe that's not going to be a fight. Maybe it is. Maybe they're just going to divide it because they know that's what you wanted. If so, then the IRS rules say that they need to file a gift tax return. Will they do it? Maybe, maybe not. But you've really complicated things by putting any child on any as a joint owner on any account of any size. So when I say that, do you have one kid on an account that's worth 10,000 and they're going to use that to pay your burial and this and that? That's okay. That's not a problem. But I'm talking about an account that is much more sizable. It's very problematic. So keep in mind, even if you don't have an estate plan and Washington says where your assets go, you're a single person under the laws of intestacy, your actions may have unintentionally caused one of your children to receive more. And you may have created a great opportunity for litigation. So let's say that you know that you only want 2 of your 3 children to inherit, then you must do a will, or you can do a revocable living trust and put your bank account in. But what the point of it is you must do your own estate plan if you want the result to be anything other than equally to your living descendants. So that is the basics for a single person. Let's go back and take a look. Let's say that you don't have any living descendants. So the answer here is no, you don't have any living descendants. Then what happens? Are your parents living, either one or both? If the answer is yes, then your parents get your estate, that which passes through the probate estate. Let's say your parents aren't living. Does it go to the state? Not yet. So if your parents are not living, then what we say is, do your parents have any living descendants? So your siblings, for example. If the answer is yes, then 100% of the estate goes to your parents' descendants. Let's keep going. The answer is no, you don't have any siblings. Are your grandparents alive? Yes, then it goes to your grandparents. No. Okay, then are any of your grandparents' descendants living? What's that mean? It means your cousins. Okay, then it goes to your cousins. No. All right, let's keep going. Do you have any stepchildren from a deceased spouse? Yes. Then there's another question. So let's start with no first. No, you don't have any stepchildren from a deceased spouse. Then the state of Washington does get your money. Okay. But let's say that yes, you have stepchildren from a deceased spouse. Did that late spouse leave their entire estate to you? If the answer is yes, then your estate goes to those stepchildren. If the answer is no, then your estate goes to the state of Washington. So you can see that the state of Washington will end up with your money, but only if there aren't any of these, what we call heirs at law, to inherit. So I started with a single person for what happens to your estate when you are deceased. I want to now move to a married person, because you would think that with a married person, it is easier. And frankly, it is, and it isn't. And I'll explain why. So let's go to a married person. Yes, you're married. Do you have any living descendants? So the answer in this case is yes, you do. See this where it says your spouse then gets 100% of CP? That stands for community property. 50% of the SP, separate property. Sorry, I couldn't spell it out. There wasn't enough room. And descendants get 50% of the separate property. All right, this is confusing. Let me back up a little bit. In the state of Washington, we are a community property state. What that means is during your marriage, everything that comes to you from your earnings, from the work that you do, is what we call community property. So let's say one person's a stay-home spouse, the other is the wage earner. It doesn't matter. It's all owned as a community, 50-50. Let's say that you receive an inheritance directly from your parent or your aunt or somebody. That's called separate property. Any kind of gift to you or an inheritance to you is separate property. So separate property, recall, goes half to your spouse, half to your descendants. Community property goes all to your spouse. So what happens is that when a person doesn't have a will and there are children from a prior marriage in particular, what happens is that there is going to be a lot of dispute typically about what is considered community property and what is considered separate property. And I encounter this quite a bit. People who maybe they did receive an inheritance, so it's separate property, but they took that inheritance and then maybe what they did was maybe they inherited a house from their parent, but the house had a mortgage on it. So now they're starting to pay the mortgage from their wages. That is changing the character of that house from separate property to community property, because it is commingling. We're putting community funds into the house to pay the debt on it. So it's not 100% separate property anymore. It's becoming community property. So anytime wages are used to pay debt on a piece of separate property, then there's going to need to be some finding of fact by the court in a probate process to say how much of this is separate, how much of it is community, and divvy it up accordingly. So the community, the separate property piece of it is really what lends itself to dispute, to litigation, to costs. And, the more that's involved, the more likely that there is going to be a dispute because people are looking after their own interests. How do you solve for this? A couple of ways. You can have a will that says where everything goes. Another way is commonly when people get an estate plan done, they might do a property status agreement, which says, for example, everything I own is owned by my spouse and me, and when I die, everything goes under my will. Lots of times community property agreements say, when I die, everything goes to my spouse. We're not as fond of those here at ELG Estate Planning, because then that might take away the protections that exist in a will. And I'm not going to get into that today, but you can characterize what your property is. You, for example, can say in a property status agreement, everything is community except for the house that I inherited from my mom, or something like that, to make it really clear what's separate, what's community. But you still need to make sure that you're not putting community funds into it unless you have an agreement with your spouse that that asset will remain separate property. Why am I spending so much time on this? The reason is this is where all the disputes come up between a surviving spouse and children from a prior marriage, based on the fact that Washington state says community property goes 100% to the surviving spouse, and half of the separate property goes to the surviving spouse, half goes and is divided among the descendants of the deceased spouse. So it is definitely a great opportunity for litigators to get involved in. Oftentimes there's litigation. And I got to tell you, as an estate planning lawyer, and especially one that used to do litigation many, many years ago, we do everything to avoid litigation. It is costly, and it is not anything that anybody wants when it comes to estate planning. Okay, I'm going to share my screen again. I was just talking about you're married, you have living descendants, what happens to your assets? Okay, so let's say you're married and you have no kids. Then the question is, are your parents alive, one or both? Now look what happens here. Yeah, your parents are alive. Same question, same thing on this community property split, but it's a little bit different. Your spouse, again, gets all your community property, but your parents get some of your separate property, 25% only, and the spouse gets 75%. But you can see there's this opportunity for dispute and litigation, though it's not nearly as much as when you got the kids involved. All right, let's say your parents aren't alive. Okay, do your parents have any living descendants? Yeah? Well, then guess what? The parents' descendants get 25% of the separate property, not the parents. All right. Let's say no, your parents don't have any living descendants, then yay, your spouse gets 100% of everything. So that is the estate plan that Washington has for you when it comes to where does your stuff go, where does your money go, where do your assets go if you don't have a will. Keep in mind, as I mentioned before, that even if you don't have a will, you may have directed your assets intentionally or unintentionally to people who are not on this chart, or maybe unequally to some kids because they're a joint owner, etc. So one of the things when we're working with clients to do an estate plan is it's not just a will. It is not just a trust. For a lot of people, their largest asset can be their retirement account. So it's really, really important that your retirement account be directed to go consistent with what your wishes are. So that is Washington's estate plan for what happens when you die. But I don't want to stop there, because I think it's really important that we talk about life's journey. What happens during that time? And most people don't even think about estate planning, what happens during your lifetime to you if you don't have an estate plan. They just think about what I just talked about, which is what happens when I die if I don't have a will, if I don't have an estate plan. But Washington has an estate plan for you during your lifetime. An estate plan is not just a will. It is not just a trust. It is having protections in place for you in the event of your incapacity. None of us like to think about the fact that we wouldn't be able to manage our own affairs, take care of ourselves, make our healthcare decisions, be in charge. Everybody wants that for themselves. However, we all do know of people in our lives who may have lost the ability to take care of themselves. It could be someone who has a form of dementia, Alzheimer's, for example. They need somebody to help them. It could be somebody who is younger, who's special needs. They need somebody to help them. They could be under a guardianship, or maybe they were able to execute powers of attorney. But you can imagine there's probably somebody in your life you know of that is not legally capable of taking care of their own affairs, or they simply need help. So what do we do to plan part of our estate planning process for protecting you during your lifetime? We make sure that you have good, effective, durable powers of attorney to handle financial matters and to handle your medical, your healthcare, your personal decisions. Under the durable power of attorney, if you lose the ability to take care of these things yourself, that document that you have signed when you were capable will say that I want this trusted person to be managing my finances, this trusted person to be talking to my doctors. And then, of course, we recommend successor designation of these agents. We just don't want to name one. We want one person, then an alternate, and then ideally another alternate. Why these documents are so important is because the state of Washington has a plan for you if you don't have these documents and if you should lose capacity. That plan is not one you want. It's not one that anybody wants. What it involves is the court taking over your affairs. What does that look like? So when somebody has lost capacity, there will be a petition filed with the court for a guardianship and a conservatorship proceeding. In the past, in Washington, we just used to call it guardianship. We now call it guardianship, conservatorship. So that's fairly recent. But basically, it means the same thing, that there is somebody who is appointed by the court to manage your affairs. And that could be a family member, or it could be a certified professional guardian, somebody that you've never met before. That person needs to, assuming that you're found to have been incapacitated, and there's this court proceeding where it's determined, there's a guardian ad litem, maybe called a friend of the court now, that says, yes, this person needs our assistance, and the court needs to appoint somebody to be the guardian. What they need to do is they need to manage your financial affairs, for example, but they need to file reports with the court because the court is monitoring all of this. They don't have, they don't have the ability to manage your affairs unless the court gives a stamp of approval. Same thing with your personal care plan. The court needs to know what is the plan, and the court needs to approve it. All of this is intended to protect you, which is what the durable powers of attorney were intended to do, but you didn't sign those under this scenario. So you didn't appoint somebody you trust, and because you didn't do that, now the court has to step in and take these actions to protect you. It's all in the court. It is all part of the court's proceedings and records and files. And I can tell you that it is, I'll say, not an inexpensive process. Sometimes people have no money, so there's, it's public pay, but typically if people do have money, then they're paying for all of this from their estate. So it's really a situation to avoid if you can. Can you? Yes, you can. Get an estate plan in place. Get your durable powers of attorney in place. Sometimes we see that hospitals are the ones that are filing for these guardianships and conservatorships because they have to. The person's lost capacity. There's nothing that can be done, and there's none of these necessary powers of attorney in place. So the hospital will file. So it is a necessity when that situation arises. You can avoid this being in a guardianship typically by simply having your durable powers of attorney in place. I failed to mention a healthcare directive. It's also called an advance directive or a living will. And that's also something that sometimes ends up in the court when it's not clear what's appropriate for you. If you are at end of life, do you want heroic measures, or would you prefer none, so that the dying process is not prolonged? That also can be part of a court proceeding. So Washington has an estate plan for you during your lifetime if you lose capacity, and that estate plan is a guardianship and a conservatorship. What else does Washington have for an estate plan for you? Let's say you need long-term care, and as an elder law attorney, much of our practice involves helping clients plan for and protect their assets, plan for and prepare for long-term care if it occurs, and making sure they're in the best position to get quality long-term care and preserve their assets. That is part of what we do with our Medicaid asset preservation strategies. So if you come to us and you have long-term care costs, we're going to be talking, or long-term care concerns, we're going to be talking with you about what's the best Medicaid plan for you. Medicaid, as most of you know, is an impoverishment program. If you just look at what the basics are of Medicaid's rules. For a single person, you can have $2,000 in countable assets. That's it. That's impoverishment. Yes, you can have your house, your car, and your stuff, but in terms of money in the bank, retirement accounts, you can have $2,000, no more. So the Washington state's plan for you if you need long-term care and you're a single person is that you spend down all of your money and then you qualify for Medicaid. And if you still have your house left because you didn't sell it, then at the end of your life, the state will be able to recover for benefits it paid on your behalf through your house. They will have an estate recovery claim against your house. So Washington state's plan for you if you're a single person and you need long-term care is that you will get the care, but you will have no assets left and your family will get none. I can tell you that if you are a single person and you're concerned about long-term care, even though Medicaid's rules are quite draconian and don't allow you to keep much money, we do have strategies that will support your care and preserve assets for your family. So don't feel like all that's available to you is Washington state's plan for you, because there are better plans. Let's talk about a married couple. During your lifetime, one of you needs care. Medicaid's rules, the state's rules are more generous towards married persons. Why is that? Because the state does have a policy against spousal impoverishment. There's no policy against single person impoverishment, but there is against spousal impoverishment. So a spouse can keep, the couple can keep between $70,000 and $150-some thousand in countable asset, which is much better than a single person, plus their car, their house, their stuff. So when one of the couple needs long-term care, then Medicaid can be used with that higher asset level. Like I said, 70,000 to about 150,000. And without more, what happens is that when the person who was receiving benefits, Medicaid benefits, when they die, the state won't collect against the house if the surviving spouse still lives there. But when that surviving spouse dies, the state will collect for benefits paid, estate recovery, against the house. So The state's plan for you, if you are a couple, is to make you spend down to a lower level standards, the resource standards, and then collect their money at the end of the day. And that might be perfectly fine with you. But what I do want you to know is that there is an estate plan, a Medicaid asset preservation strategy that allows you to keep much more money than that 70 to 150,000. It allows you to completely, in the state of Washington, avoid any estate recovery on your assets as a couple and keep your spouse on Medicaid, even if the well spouse, the one who's not on Medicaid, dies first. We can do estate planning that allows all of the assets to be protected and go into a trust on the death of the first spouse and not kick that ill spouse off of Medicaid. So, of course, the state of Washington is not going to do any of what I just discussed about how to protect your assets of the couple and make sure that the well spouse has assets and how the ill spouse won't be bumped off of Medicaid, and how ultimately at the end of the day, for example, if you have children, your children get your assets, not the state of Washington. So that pretty much is Washington State's estate plan for you. So let me take a look and see if we have any questions that I can answer. So a question is regarding community property savings and investments. Can you use your beneficiary designation of your spouse and children for community property equally, or does it have to be 50% to the spouse and the rest to the kids? The answer to that really depends a lot upon what the asset is. Let me give you an example with like a 403B, for example. Any kind of employee retirement plan that's governed by ERISA, it usually says that the spouse must be the beneficiary. This is under the plan rules. And for anybody other than the spouse to be the beneficiary of the estate, then the spouse has to consent to that. That somebody else other than them gets, for example, half of the assets. So that is for a retirement plan governed by ERISA. IRAs will have not that same strict sort of restrictions. So yes, I can see definitely that the IRA, for example, without any kind of constraints, would be able to pay half to your spouse, half to your kids. When it comes to any kind of financial asset, you need to talk to your financial advisor, to the company that is holding the asset, to see what rules and constraints and restrictions that they have. And again, caveat to everybody who's listening now or in the future, I cannot give you individual legal advice. This is education to help increase your understanding and your awareness. So, having said that, let me go to the next question. The parent has income of $3,600 per month and $150,000 in the bank. She'd like to give it to the kids, the grandkids. And what's her best option? Give it away? What if she goes to nursing home care? Help with figuring out what's the path forward. So Medicaid has a 5-year look back. What that means is if you give assets away within 5 years of applying for Medicaid, then Medicaid's going to say, well, you gave your money away. So no, you're not going to get Medicaid now. We're going to impose what's called a penalty period or period of ineligibility. Right now, in the state of Washington, the rule is for every $11,899 you give away, you have a 1-month period of ineligibility. So, If you give away, 110,000, for example, it's about 111, it's about a 10-month period. So the general rule I say is do not give away your money unless, or mom's money, unless mom does it as a part of a Medicaid asset preservation strategy. We at ELG Estate Planning often will help a single person who's going into care protect, preserve their assets. There are Medicaid programs that have no penalty for giving away money. There are other strategies that allow us to, give away money and incur a penalty period, but still protect those assets even during the penalty period. There is just absolutely no way that I can say, what is the answer to this question? What is the right plan for you? Medicaid is a pretty complex area of practice. It is something that's practiced by elder law attorneys, but not all elder law attorneys. So when you're looking to get answers to your particular questions, definitely see an elder law attorney. Ask them, and do you have Medicaid expertise? Because I can tell you, as an elder law attorney for many, many years, I know that many of my colleagues don't touch Medicaid, because if you're doing Medicaid, you better be all in. You have to know the rules. Nobody dabbles in Medicaid. It's just not a good idea. So when you're talking to your attorney that you're, vetting to see whether they're appropriate for you, find out, is Medicaid, a part of your practice? And if so, for example, can you tell me, are you currently doing medications and Medicaid plans? Is this something that your firm frequently does? And if you say, yeah, I've done one before, I wouldn't recommend that. Find somebody who really, really knows Medicaid, because and if you are watching this later, or we'll give you a link to our YouTube channel, there are some very good, effective strategies to preserve assets and qualify a single person for Medicaid. So it is like my favorite topic to talk about. I know we're talking about Washington's estate plan for you. If you don't have a plan, it kind of fits in, because Washington's estate plan for you for Medicaid is spend it all down, which is not the plan that I would recommend. Another question: can I set up a trust that will provide for my children even though I'm married? Children are from a previous marriage and spouse doesn't have children. Is there any legal rights I have other than giving all of my assets to my surviving spouse and nothing for my family? Absolutely. This is not uncommon that you have, a marriage, a second marriage, and kids from a prior, blended families. There is a lot that you can do to make sure that your children are provided for. There's a concept called unintentional disinheritance that comes about when people have what I call an I love you will. I give everything to my spouse outright, no protections. And what happens? They remarry. My kids get nothing because the new spouse and the new spouse's kids get everything. Any estate planning attorney will be able to walk you through how you can ensure that your children inherit either from you upon your death or upon the death of the second spouse. There are definitely ways to accomplish that. All right. Well, I think that we have covered most of the questions. Oh, let me see. There's some over here in the chat. Here's one about Medicaid. If a Medicaid recipient earns $2,400 a month, will that money exceeding their limit be applied toward the care? So this is a question that comes up quite frequently, that, as I mentioned, Medicaid has a resource standard of $2,000. Medicaid's income standard is far higher than that. In fact, it's like for people receiving care at an assisted living or adult family home, it's over $10,000 a month, and they still qualify for Medicaid. So how do we reconcile this income and the resource standard? Well, when somebody is on Medicaid, they have to pay what's called participation. So let's say that the person's income is $5,000 a month, and they're at an assisted living facility that is now accepting Medicaid for the person. So what happens is the person has spent down all of their savings, their checking, to $2,000. They qualify for Medicaid, but every month they get $5,000 from their pension, from their Social Security. Medicaid says, okay, you take that $5,000 that you get, we'll let you keep a deduction for personal needs allowance of a little bit over $100. And then the state typically pays for Medicare and for Medicare supplemental. So the other $4,900 needs to be paid to the facility. And if the facility is getting paid, their cost of care is like, let's say $6,900, then the state pays the other $2,000. I know I'm getting into a lot of detail here, I apologize. But what it means is that the person's income goes in and goes out, in and out, never accumulates, because all they really get to keep is $100. That's it. So having income well in excess of $2,000 is not a problem for being on Medicaid and staying on Medicaid. Let's see. Do I need to correct my 401k rollover IRA to have only my spouse, the only beneficiary, instead of shared with the kids? I would check with your financial advisor and what rules that the company has. Typically, a 401k rollover to an IRA now has IRA rules that are different. I don't know if the 401 rules carry over. Definitely check to see what you can do with it. Whenever it comes to like financial accounts and what are the rules on financial accounts, we as the attorneys always defer to the financial company because they have their own rules. They're not, estate planning rules. I would mention though, because it just kind of clicked in my brain, that if you have a 401k and you got it when you were married, to your first spouse, and then you divorced your first spouse, and then you remarried, and maybe you forgot to change your designation to your new spouse, you just didn't even think about it, there is the possibility on your death that your divorced spouse gets your 401k. So there is definitely that possibility that has occurred in the state of Washington before. So check your 401k beneficiary designation to make sure it goes where you would want it to go. Right. Okay. Well, I think I have answered the questions. Let me double check here to make sure. A couple more here, and we still have a few more minutes. So if you want to stay with me, I'll answer some more questions. We live outside of the Seattle area. We actually do have an office in Seattle, and we are able to serve people in the Seattle area. And if you live near or around Seattle, you know that Zoom meetings are very, very common, especially, since we've all, in the post-COVID era. So please, reach out to us, and we definitely may be able to assist you. And we'll let you know when you contact us if our firm will be a good fit. And if not, we always seek to help out the caller by referrals to an appropriate law firm if we're not the right law firm. It is common or suggested that the executor of an estate should already have a durable power of attorney in place. So a durable power of attorney is a document that is in effect and in place during the principal's lifetime to protect them during their lifetime. And the decision maker is called the power of attorney or the agent, not the executor. An executor is a word used for who implements or administers the will. So just to be clear on our terms, keep in mind that power of attorney document is in effect and in place only while that person, the principal, is alive. Once they die, then what happens is either their will, or if they don't have a will, laws of intestacy, or if they have a trust, their trust, that comes into play. Durable power of attorney expires when the principal expires. So I would say, my opinion is that the durable power of attorney is the most important document that you can have. Make sure your loved ones have it, especially if you're trying to help mom with her care, for example. She needs a good durable power of attorney while she has capacity to execute it. And elder law attorneys, we often work with people with diminished capacity to support their autonomy. Just because somebody has a diagnosis of Alzheimer's does not in and of itself mean that they don't have legal capacity. It is only when we meet with somebody and we know that it's just, they're not really following anything we're talking about. They don't get it. You probably have seen that situation with people in your life. Then no, we can't help. It's too late with getting a durable power of attorney in place. But even with people with diminished capacity, we can help get a power of attorney in place. And as long as that person has the ability to make their own decisions, let them. That's their right. It's only when they lose the ability to make decisions do you step in as the power of attorney and carry out their wishes. So don't wait till it's too late to get that power of attorney in place. I hope that you found this information helpful. Again, my name is Lynn St. Louis. I'm the founder of ELG Estate Planning, Elder Law Group. We have offices in Seattle, Tri-Cities, and our headquarters is here in Spokane. We would love to be able to assist you to answer your questions. In the chat, it says how to reach out to us. Our phone number here is 509-468-0551. We have a website with lots of information. We have a YouTube channel. We really would appreciate if you find it helpful to check out our YouTube channel, to subscribe, to share this information with anyone that you believe might benefit from it. One of my personal goals is to help share information so that people can make the best decisions for themselves. So thank you for sharing your time with me today. I very much appreciate it, and I wish you a great day. Thanks so much.